A has consensual sexual relation with Z's wife. C gives to A a valuable property which A knows to belong to her husband. This is the last question we'll do today. A has consensual sexual relations with Z's wife. C gives to a valuable property which A knows to belong to her husband Z, and C has no authority from Z to give. A takes the property dishonestly. What offense has been committed by A? Yes, Smita has already given the answer, but is it so clear? You call it theft. All right. What is required for the offense of theft? Moving of property. The act is moving of property. And with what intention? The intention under the for the offense of theft is intending to take dishonestly. Intending to take dishonestly the movable property from the possession of somebody without that person's consent. Now, in this case, was the property taken out of possession of Z without his authority? Then only it will be theft. A has taken the property, he has moved the property, and his intention is to take the property out of Z's possession because the property belongs to Z, out of Z's possession without Z's consent. But was the property in Z's possession? Yes, Smitha, you are right. Illustration O, but let's understand. Yes, you are right. Illustration O is right. But was the property in Z's possession? Tell me, because the property must be in possession of the person without whose consent it has been alleged to have been taken. The property was not in Z's possession. The property was in the wife's possession. Yes, you have hit on the nail. The property is actually in the wife's possession, and the wife is giving it to A. The wife is giving it to A with her consent. With her consent. Whose consent is required? It is the consent of the person who possesses. For the offense of theft, please remember the consent of the person who possesses the property is required, not the consent of the owner. We are not concerned with the legal owner of the property. We are concerned with the possessor of the property. For the offense of theft, what is required is that the property is intended to be taken out of the possession of the person without his consent. So consent of the possessor is required. Now in this case, who possesses the property at that moment? The wife possesses it, and wife's consent is taken. It is not without her consent. If the property is taken from the wife with her consent, where is the question of theft? The property is taken from the wife with her consent. That's what I am saying. Anybody other than Smita? Yes, IC says D, criminal misappropriation, not theft. Okay. Himanshu, what is it? Josna says A, criminal breach of trust. Criminal breach of trust by whom? For criminal breach of trust, the property must have been entrusted to somebody and that person has misappropriated it. Yes, Shruti has given an answer. Himanshu also says C. All right, so I have received answers from most of you. The correct answer is C. And the reason for the answer I will show you. First, 378. Whoever intending to take dishonestly any movable property out of possession of any person without that person's consent moves that property in order to such taking is said to commit theft. So for committing theft, the property has to be moved, the property has to be movable property, and intention should be to take dishonestly out of possession of any person without that person's consent. Which person? The person in whose possession the property lies. So consent is required of the person in whose possession the property is. If we say that this property was in the possession of the wife, then it is not theft, because the consent of wife is already there and there is no theft by A. But legally speaking, the property is not in possession of the wife, and the reason lies in section 27 IPC. When property is in possession of a person's wife, clerk or servant on account of that person. On account of that person means the person is the owner, but the property is in wife's possession on that person's account, on that person's behalf, then legally speaking, it is still in that person's possession within the meaning of this code. So because of section 27, the property is still in the possession of the husband, even though physically it is in the possession of the wife. There is a difference between physical possession and legal possession. The difference is because of section 27, that property, what is the property? Whatever was given to A, that property was in physical possession of the wife, but legally it was in possession of the husband. And since husband's consent was not taken, it will amount to theft. A took that property from the wife without the husband's consent. The husband's consent may be implied, but in this case, the implied consent is not there. And therefore, we say that the offender took the property out of Z's possession, the husband's possession, because it is still legally in possession of the husband. It is not in legal possession of wife. It's only in physical possession of wife. Legal possession is still with the husband. And since A took that property out of the legal possession of Z without Z's consent, it will amount to theft.